The hearing kicked off with Trinidadian Senior Counsel Douglas Mendez laying out his reasons why the Court of Appeal exceeded its jurisdiction when it interpreted Article 177(2) of the Constitution to say more votes are cast should mean more valid votes are cast. Mendez is among a battery of lawyers representing the applicants, PPPC's General Secretary Barry Jagdeo and presidential candidate Irfan Ali. He cited the Esdin David submissions the Court of Appeal had ruled on. He pointed out that they failed to reach the threshold for jurisdiction under Article 177(4) of the Constitution. His argument is that if the Court of Appeal exceeded its jurisdiction, then the finality clause does not apply to the case.
What we have submitted and what I have been at pains to submit this morning is that the decision that the court made, and indeed the proceedings themselves, were asking the court to make decisions that did not fall under 177(4). And as I've just indicated, the last submission that I was making, the jurisdiction that the Court of Appeal has under 177(4) is to determine questions as to validity that depend upon the interpretation of the Constitution. So if it determined a question as to invalidity, which depended upon the interpretation of something else other than the Constitution, then that is not a decision under 177(4), and therefore it is not a decision that is caught by the finality clause in 177(4).
Next in the lineup was Senior Counsel John Jeremy, who represents David. He sought to rebut Mendez's arguments shortly before lunch. In the middle of telling the court that Mendez cannot tell him what an election is, CCJ President Adrian Saunders interjected to ask whether there is any precedent for his arguments. In fact, Jeremy had cited a case which CCJ Judge Maureen Rajnath Lee noted is actually harmful to his position.
Mr. Jeremy, do you know of, or have you been able to cite any case where a question as to the validity of the election of some governmental official was heard and determined by the courts before the official was elected?
My Lord, I have not been able to find such a case.
Mr. Jeremy, thank you much for bringing to our attention, I believe it's the Ryan Carey case, the one that you just cited. It's interesting that in that matter, the petitions were seen as premature because it said that power that was in the Supreme Court to inquire into and decide the doubts and disputes arising out of and in connection with the election of the president can be exercised only after a particular candidate has been declared elected. So I appreciate what it says about how you have made your submission, how you've couched it with respect to what is an election. But still, the result was not in favor of the petitioners.
It was not until 16:25 hours in the afternoon that Jeremy was able to cite his precedent, a Mauritian case from 2011 that the Privy Council decided on. Meanwhile, Senior Counsel Reginald R. Moore, who represented Joseph Harmon, sought to tell the court that it was venturing into areas it shouldn't be. At the end of the hearing, the court decided on next week Wednesday at 1500 hours to make its ruling on the issue of jurisdiction and the substantive appeal. Gerald Bryan, The Evening News.